Well, welcome everyone to the Friday edition, April 30th, end of the month, the Employer Handbook Zoom office hour. My name is Eric Meyer. I am an employment lawyer at Fisher Broyles, and I'm also the publisher of the Employer Handbook blog. That is theemployerhandbook.com. I am fortunate, so fortunate today to have my partner with me, Susan Warner, my employment partner. Susan, well, we got a lot to talk about today. And I've already been talking about on the blog. I think she got the biggest ADA win of 2021, but we'll work up to that. For right now, let Susan introduce herself. Susan, thanks for being here. How you doing?
I'm good. Thanks for having me. Hello, everyone. Susan Warner, partner at Fisher Broyles. I am a litigator who specializes in employment law and commercial litigation.
Awesome. Thanks so much for being here. So, folks, two lawyers about to dispense some knowledge over the next hour. But remember, we're two lawyers, but we're not your lawyers, okay? We don't give legal advice here. We assume all the questions you ask in the chat, use the chat feature at the bottom, you're asking hypothetically for a friend. And if we respond, we'll probably say it depends, just like your lawyers would, but don't be confused because you're not paying us. Our clients pay us. So we're not giving any attorney-client, we're not creating any attorney-client privilege, and we're not giving any legal advice. But please do ask those questions. We'll give as many answers as we can. Also, again, for people who are just joining us now out of the waiting room, there is a closed captioning feature if you need it. It's either the CC button on the bottom of your screen, or if you click the three dots that say more, you'll find a live transcript or subtitle settings. You can play around with it, but you shouldn't have any issues with viewing the closed captioning if you need it. So with that disclaimer and all that fun stuff out of the way, let's talk ADA, but not the ADA that I'm sure a lot of these folks are used to. We're talking about Title III of the ADA. So Susan, can you give these folks a little bit of an overview of Title III and what that's all about?
Sure. Title III of the ADA applies to access to public accommodations. As you all probably, of course, you all know, Title I applies to employment and employment discrimination based on a disability or a regarded disability. Under Title III, that is the part of the statute that tells businesses you have to have your ramps at a certain angle, your bathroom door has to be so wide. And so that is the mechanism for the general public to have, I guess, regulations in place to ensure accessibility to, and the term under the statute is places of public accommodation. And there's 12 categories in the statute. I don't know all of them off the top of my head, but you know, it generally encompasses the things that you would imagine: retail stores, grocery stores, inns, gymnasiums, anything, any type of business generally that would be more or less open to the public. Like you could walk in off the street and say, hey, I want to buy this candy bar. And so there are very detailed regulations under that statute that, as I'm sure if any of you all have had to start a business or go through permitting when you're building out a space, that, you know, you have to have grab bars in your restroom at the right angle. You need to have open walkways for people, particularly with wheelchairs, to be able to get through. And that's basically Title III in a nutshell.
Well, I know it's not on that list of 12, and we'll talk about it in a bit. Websites.
Right.
That's a big one. So there are some similarities between Title I and Title III. We have this concept of disability. That's basically the same, right? We have this idea of accommodations. That's pretty, well, it's similar, right? Under Title I, we have the obligation to accommodate a qualified individual with a disability if doing so will allow that person to perform the essential functions of the job, and as long as it doesn't create undue hardship. And it's a similar analysis under Title III, right, Susan?
Generally. So there are building, like the ones I referred to, there are building design standards that buildings have to comply with. So, and that's kind of where the Title III is mostly directed at. It is making, you know, the classic is having ramps, having a ramp into your business. So, you know, for accessibility for disabled persons. That is pretty much a strict liability type of thing. And in this day and age, you know, if you were doing any type of new construction or modification to your property, it's going to be part of your permitting process. You know, your local and state entities that give you permits are going to be requiring that to happen. So that's sort of, you know, there are exceptions, like if it's too much of a hardship, if it's a historical building, if it's going to change the nature of the property too much, you can sometimes get out of those things, but generally that has to happen. The other, and I should have mentioned this before, the other aspect of Title III, which has to do with accessibility still, has to do with a provision of auxiliary aids, things to help disabled person use the goods and services of whatever your business is. And so an example might be if you provide, if someone comes in, I guess, you know, having closed caption on any video feeds you have in the store or something like that. That's actually a classic lawsuit. The drive-by lawsuit is you're not putting on the closed captioning in the TV in your waiting room so that, you know, hearing impaired persons can't read the screen. So that area, and sometimes even with the physical stuff, a lift for a pool. This is another one. You know, hotels, like, do you have a way for people with physical disabilities to get in the pool and getting a power lift to lower someone in? Those become a bit more like, you know, how expensive it is, how much is it going to cost the business, how hard is it to install that piece of equipment in that property, and how does that correspond to the person's needs? So that is where you kind of get into that, what you're familiar with the accommodation, like what is the person requesting and how reasonable is it? Can you do it or can you not? And how reasonable is the request?
Yeah, I had to counsel a client the other day on a barking service dog and how many barks, you know, the dog could bark before the dog was out of control, and you could ask take the dog out. I know the answer now.
I'm gonna go out on a limb and say if the dog's barking a lot, it's not really a service dog.
Yeah, we'll see. Anyway, so you mentioned how these lawsuits are, well, we were talking beforehand, before we got on, and what you often see with these lawsuits, folks, is kind of a tag team. You have a plaintiff. I don't want to call the person a professional plaintiff, but let's just say that that person has been the plaintiff more than once with the same attorney more than once. And they'll visit your location, your physical location, or maybe not. Maybe they'll go on Google Street View and they'll look at your location and they'll see, for example, is the entrance ramp banked at the right angle? Are there the right number of handicap spots in the parking lot? And if not, they file a lawsuit. They might file several lawsuits against several different businesses. And Susan, what's the lawsuit gets filed? What's then the formula that seems to happen after the lawsuit gets filed?
Well, when you're doing a general physical location Title III case, you know, at least my general formula is, you know, you get the complaint, you review the allegations. Generally, it's advisable to retain an architect who's an expert in ADA accommodation, or, you know, regulations and design standards, and to go out and inspect the elements that are flagged in the complaint. See if it really is out of compliance or it's not. And I mean, quite honestly, if things are not right, your ramp's not at the right angle, your door's not wide enough, whatever it may be, then truthfully, usually the best bet is to just find a way to settle it and agree to fix those things. Because it's those type of cases, you're not gonna win when you get, you know, if you got to trial and you've got a really set in stone hard regulation that says your ramp has to be at a, you know, 15-degree angle. I actually don't think that's the angle, but, you know, and your ramp's at 20 degrees. Well, you know, there's no real defense to that, because even though it might cost you some money to fix it, it's not cost prohibitive, and you're under notice that it was supposed to be done a certain way. You know, so generally, like, it's, you know, I do a lot of these cases. How intensive they get depends on the plaintiff's attorney. Some, they just want to settle right up front, and you can usually get out for, you know, a small amount of money. Others kind of make you go through a few hoops. I think they want to justify a larger attorney fee ask in the end. But generally, you get inspected, you find out if anything's wrong, and then you agree to fix it. And you usually resolve it pretty quickly.
Yeah, that's the problem with defending these cases is you're generally chasing your tail the longer these cases go. I mean, unless you're going to win, the attorney's fees on both sides, your client's paying you to defend, so that can add up after a while. We have reasonable rates, but it adds up after a while. And then if the plaintiff prevails, you're not only responsible for the remediation to fix the problem. And again, it's pretty much a strict liability statute. It's not like if you're close enough, the court will let it go. No, you got to fix it. And then you've got to pay the plaintiff's attorney's fees. So these cases can get expensive pretty fast.
Yeah. And I'll add something. I mean, I've had, I can guarantee you right now, if any of you have a business with like a public restroom and you sent an expert out there right now, your grab bars are going to be off by like half an inch. The mirror every single time is going to be off by 1/4 of an inch, according to them. Like, it is inevitable. And I mean, I see this a lot because I have clients, retail stores with restrooms that are open to the public as part of, in the store. And but these things, if we got down to the nitty gritty, are they really impairing anyone's access to the store and their ability to avail themselves of the goods and services of that business? No. Like a grab bar being off by 1/4 of an inch is probably not a real material barrier to a disabled person's access. But Eric just brought up the point. As much as sometimes I would love if my clients would pay me to like fight this to the end, because we all assume it's a strict liability standard. And I think generally that's true. The problem is no one's ever like taken it all the way to test that out because, it's too expensive and there's too much risk because, there are regulations and like, are you going to go to the mat over a 1/4 inch mirror off when, either you can just agree not to fix it and like pay them a settlement of attorney's fees that's far less than it's going to cost to take it all the way to trial. And so that's why most people settle, because it's just too expensive to litigate it to the end, to fight to the death over a grab bar being off half an inch.
Yeah. We've seen Title III come up in COVID times in a different context, not so much whether the grab bar is installed right, but really we've seen it in terms of screening for COVID and face masks, right? So someone shows up at a big box store and they say, "You gotta let me in," or I can't breathe with a mask on, right? I got a problem. You gotta let me in without a mask. But no, they don't, right?
Yeah, that's not really a Title III. People claim like, oh, the ADA protects me, and I'm like, it does not. And particularly the government has said you can require people to wear masks. It's a public health situation. So yes, I've yet to see a lawsuit that is challenging that under Title III. But yes, I've seen the videos of patrons claiming that they are, HIPAA and ADA protect me, and no, it does not.
I saw one. I thought there was a Title III claim. It's been a while since I blogged about it. It involved a giant supermarket up in Pennsylvania area, where there was a gentleman who, same type thing, showed up at the door. I think it was Giant and or Giant Eagle, something like that. And they wouldn't let him in because he didn't have a mask on. He said, I can't wear a mask. I need it. Because of medical reasons, you have to let me in. And they said, sorry, our rule here is for the safety of everyone. You gotta have a mask to come in. Yeah. So he turned around and sued, and he sought an injunction. And there were some problems with his case. First, notably, the supermarket had curbside, which curbside contactless pickup, which he could have availed himself of and didn't. So there were some options for him. He could have had the same enjoyment of the shopping experience at a Giant Eagle going in the store or pulling up to the side of the store. The other issue he had was he was a little outspoken on social media, and talking about how he really didn't have any problems breathing, and he really undermined himself, and all of those Facebook posts were attached to the defendant's opposition to the injunction. I think the case went away pretty quickly.
That is, so, if you were the plaintiff bringing one of these suits, like some of the elements that they have to prove, one is you're actually disabled. You have an actual legitimate disability that impairs a major life activity. And that whatever this barrier is actually creating a complete barrier to your ability to access the store. In my experience, I can tell you, I've had plaintiffs suits against my clients where they, I'm the complaint is I'm in a wheelchair, I'm paraplegic, et cetera, and then we have the video of the person checking out of the store based on the receipt they've attached the complaint showing they were there, and the person is pretty upright and ambulatory for someone who is allegedly in a wheelchair. That one went away pretty quickly once I shared the video with plaintiff's counsel.
I think of that episode of Seinfeld where George is going away on the motorized scooter and the battery runs out on his 4 volt. Like, he doesn't have the 6 volt, and he ends up picking it up and running along, and Mr. Tomasulo comes along and sees him and goes, George, what happened? Yeah. So,
if you were defending a suit, you can always, ask, give me your medical record, show me that you have a disability. But of course, when you're getting down to fighting over a grab bar, is it worth, unless that plaintiff is going to keep coming after you again and again. But that is an aspect, a defense, that the person may not actually be disabled, which does happen. And then having alternative access. I think there's a misconception about the ADA that it is guaranteeing you complete, equal, identical access for disabled persons as non-disabled persons. A lot of times that's not possible. I think the classic, I'm going to go back to the ramp, a ramp versus stairs, they are different. It's not the same way you would physically get into the store, but you're still getting there the same way. And so that is built into the law that, what needs to be provided is accessibility to get the same goods and services. The ultimate product in your hand is what the law is trying to achieve. The manner in which you get that product in your hand can vary, and quite often has to, because of, just the nature of physical locations and access. And so the fact that they had curbside pickup is a classic example. He didn't need to go physically into the store to get whatever goods and services he needed. They could bring it outdoors to him. I could think of a counter argument for the plaintiff side would be like, oh, well, it cost me, $5 to do that. Well, then the store just says well, we'll waive the $5 for you, and that would be like, if I was, giving advice to that client, I'm like, just waive the $5, if you can't wear a mask because you've got some disability, but we are requiring a mask, we'll bring the groceries out to you and we won't charge you that fee. Done. Problem solved.
I just want to point out to folks, make sure you're following along in the chat. I see my friend Bill Gorin is attending today. He's got a wonderful blog, understandingtheada.com. He posted a link to his write-up on the Giant Eagle case. And Kathy writes that they had a patron not want to wear a mask inside, so he offered all services outside, even allowing a laptop outside and a chair so they could sit down with the laptop. Problem solved. That's
problem solved. You will get people who will fight back and say, that's not good enough. I want to be able to come in the store and, be maskless, and you're discriminating against me. But, particularly in COVID, when there's public health reasons as to why you do not want to be allowed people in a confined space, indoor space without a mask. I doubt a judge in the country would be like, yes, that's a violation of the ADA. You have to let them in maskless, right. Providing them access to the goods, that is equal as far to the end result, is really kind of the main goal of the ADA. And always what you want to keep in mind when you're trying to comply with the law is trying to get everyone to the same endpoint. And how you get there may vary, but giving them the ultimate product is what you want to focus on.
That's a perfect segue into, is it Heel or Gill?
Gill.
Heel versus Winn-Dixie.
Yeah.
So this is a case absolutely about, are you giving, well, one, it's about, is a website a public accommodation? Is that a place of public accommodation? That's one issue. But the other issue, and I'm going to let Susan explain it, is whether you're giving someone who uses a website, in this case, the Winn-Dixie supermarkets. And mind you, folks, this is back in 2016. So everything we're dealing with here, the facts relate back to 2016. Law doesn't always move that quickly, or the justice system. Are you giving someone the same experience when they use a website versus when they come to the store? So Susan, why don't you tell the folks who aren't familiar with this case and websites and Title III generally, what this is all about?
All right, so this case, as Eric mentioned, originated about, well, I guess now 5 years ago. And it was part and parcel of, at that time, there were a lot of these lawsuits being filed. And the basic premise of the lawsuit is, I am a visually impaired, the plaintiff being, I'm a visually impaired person. I use screen reader software to navigate the internet. And for those of you who may not know, screen reader software does exactly what the name says that it does. It is a software program that a person would have on their own computer that can read what's on the computer to them. Some of it has functionality where if it's programmed correctly and the website is compatible with it, often the user can use their keyboard just like a mouse. So they can get the drop-down menus and kind of navigate around the internet and their websites the same way you and I would do being sighted and using a mouse. So the lawsuit that against Winn-Dixie and others of the same, the premise is the ADA applies to websites because first, websites are places of public accommodation under the ADA. But two, even if they're not places of public accommodation, they're covered under this, what's called the nexus theory, or what was, still is the nexus theory, that the website has a connection to the physical location, and therefore it gets kind of encompassed into that physical place. And the reason why you're not compliant, business, is that you did not design your website correctly to work with my screen reader software. So when I go to your website, I try and click around, it's like completely inaccessible. I can't get it. I can't read anything. I can't comprehend the information. And therefore it is a barrier to me being able to get access to the goods and services of your physical store.
So Mr. Gill,
with a hard G.
Oh, Jill, I'm sorry, Mr. Gill.
Yeah.
Mr. Gill, his complaint was that the website offered the ability to refill existing prescriptions for in-store pickup, and also the ability to link digital manufacturer coupons to a rewards card that you'd use in the physical store. Yes. And because he claimed that the website wasn't set up because he had site issues, wouldn't accommodate him, that he was being treated differently than other folks who could use the website and then go to the store. That's basically it, right? That's
basically it in a nutshell.
Yeah. So as I alluded to earlier, this doesn't get decided just like this, right? This case is filed back in 2016, 2017, and it goes to trial, and then it goes up on appeal, and then finally, in 2021, we get a decision from the 11th Circuit Court of Appeals. And do you want to tell the folks a little bit about that?
Love to.
Yeah.
So I mentioned we went to trial. Our defenses in this case were, one, websites are not places of public accommodation, particularly the case law in this area of the country in the 11th Circuit, but also nationwide, there is a circuit split as to whether the ADA applies to intangible spaces versus physical spaces, and the 11th Circuit and the 9th Circuit and some other circuits say, no, it only applies to physical locations. But then they had this nexus theory. And our argument on the nexus theory was, first, everyone's been interpreting this wrong under the case. The case is out of the 11th Circuit here in my area of the country. That is kind of where they got this nexus theory from. And without going into like great detail on that case, that one had to do with a game show. And the only way someone could get on that game show, kind of like American Idol or something like that. I mean, but to become a participant, I think it was actually
I think it was Who Wants to Be a Millionaire, right?
It was Who Wants to Be a Millionaire.
Yeah.
And the only way you could become a contestant on Who Wants to Be a Millionaire is you had to do this call-in. And the phone didn't have, I think
TDD.
TDD. I think it didn't have TDD because it was for hearing impaired persons. And they said, because the phone, even though it's intangible, because it's the only point of access to get to that physical studio location and it doesn't work, it is creating an intangible barrier to you to get to the location, and therefore it's covered under the ADA. I think it's important in that case. It was a motion to dismiss that was coming up, so they hadn't got into any of the discovery, the factual issues. But the studio had said, well, this, kind of the real issue that was on appeal and what had happened was that the studio had argued, well, the phone line in and of itself is not a place of public accommodation, therefore it doesn't apply and we win. And the trial court had agreed, and 11th Circuit was like, no. It could still create this intangible barrier because it's the only point of access. So in our case, I was saying what Mr. Gill's problem was factually, particularly, was the website was mostly just informational. It had a few of those functions. You could refill a prescription, you could get digital coupons linked to your Winn-Dixie rewards card, but you could still get the same things in the store. And Mr. Gill particularly testified at trial that he was a 15-year customer of Winn-Dixie, refilling prescriptions, using coupons, going to stores all over the state before he learned of the website. So, we're saying it's clearly not an actual barrier to his access because he was able to get to the store and avail himself of all the goods and services for 15 years before he even knew this website existed. We lost. And so we were on appeal, and the decision finally came out, was pending for 2.5 years after oral argument. But the 11th Circuit agreed with us. They first said that yes, websites are not places of public accommodation, which is the first time any court in the country has said that definitively. And secondly, they rejected the whole nexus theory that the 9th Circuit had recently adopted. The 9th Circuit did adopt that argument in a Domino's case that came out a year or two earlier. And the 11th Circuit has said, no, just because it has a connection doesn't automatically rope it in. In order to maintain a claim, you need to show that this website is acting as an actual barrier essentially that it's the only point of access for the physical location, and that is preventing you, plaintiff, from accessing that location.
Yeah, it's just like trying out to be on Who Wants to Be a Millionaire. If the only way you can order your Domino's pizza is through the website or through an app, right? It's very fact specific. That could lead to a different outcome in the case, right? I mean, just because Winn-Dixie prevailed in the 11th Circuit on this kind of does it create intangible barrier to access doesn't mean that everyone else, even in the 11th Circuit, is safe if you have a website, right?
Right. And I think I can see William's question about what do you think is an intangible barrier? I mean, I think, it gets a little esoteric, but that kind of plays into it. I think under the way the case law is, and what we argued, an intangible barrier would have to be something that, kind of in effect acted as a brick wall. You cannot get to, the end point to, like we talked about, to the end product because of whatever website, phone line, what have you. And I actually got this question directly during oral argument, if the website functioned the same way, if the telephone had been a website, back then with the same type of problem, would they not have a case? And I was like, no, if the website was the only way you could get to the access to the physical location, I think you've got the same analysis. I think probably the problem going forward for plaintiffs will be, under our decision going forward in the 11th Circuit, is it's going to be really hard to show that a website is your only point of access to getting to a physical location. Because stores are open, you could easily drive up and walk in and avail yourself to the same services.
Unless you're an e-tailer. I mean, Amazon or some kind of direct to consumer. Yeah.
So then, but this is why, and this kind of one of my points in the lawsuit and in this appeal, and why, is Congress needs to take this up. Congress needs to deal with this because as the law currently stands, particularly with the declaration at an extra level about websites are not places of public accommodation, e-retailers with no physical locations ADA does not apply at all. Like it's not, there is no nexus argument because there's no physical location to tie it to. Having a physical warehouse, that's not a place that's open to the public. So that doesn't fall under it, which, coming up into our case, particularly when we were litigating it, 5 years ago, even though there was very little case law having to do with websites, but the way it had developed, particularly in our area of the country and then other circuits, you kind of had this almost ridiculous juxtaposition where, Winn-Dixie, who has an actual physical store where people can go in and get groceries, was going to come under the ADA because it also had a website, but Amazon and eBay don't because they don't have any physical stores. I mean, it really doesn't make a whole lot of sense as far as like the larger functioning of commerce in society, but that's where the law was and kind of still is actually at this point.
Unless if this goes up to the Supreme Court, because now we have a split in the circuits, that's something theoretically, I don't want you to put on your, look in your crystal ball too far, because there's probably some strategy here that you don't want to reveal, but theoretically, the Supreme Court could take on the issue of are websites covered under Title III, right?
Yeah. Sorry, I'm looking at like Bill's argument about.
That's it. While you're looking at that, I want to point something out to the audience for some of the non-lawyers who are attending here. We talk about Susan and I talk about the 11th Circuit, like, oh, hey, everyone knows the 11th Circuit. So the 11th Circuit is in the southeast part of the United States. We're talking about Florida, Georgia, who else? Alabama.
Florida, Georgia, Alabama.
Florida, Georgia, Alabama. So those three states comprise the 11th Circuit, okay? So this ruling in the Gill versus Winn-Dixie case is binding on businesses that operate in those three states. It's not binding on anyone else. And in fact, what you see are lawsuits because plaintiffs and their lawyers in these types of cases are, I don't want to say the word opportunistic, but savvy, right? So they file in circuits where the case law is much more favorable. So for example, I was on, I forget whose website it was the other day. I'm going to say it was Seyfarth Shaw. I want to give appropriate credit, but I think it was Seyfarth. I was looking at the spike in website related lawsuits over the last couple of years. And you have 2017, there were 814 filed. 2018, 2,258 filed. It was pretty flat in 2019. And then we went up to 2,523, which were filed in 2020, 75% of which were filed in the state of New York. So, this is very much a forum shopping, advantageous course of litigation. And it will take, as Susan said, the Supreme Court or Congress or the Department of Justice or some combination to basically resolve whether websites are covered.
Yeah, I'll ask Christy Davis's question about the Fifth Circuit. As far as I know, they have said nothing. But I imagine if it ever came up to them, they would probably go along with what the 11th Circuit did. Yeah. I weirdly know this. I think part of the reason you don't see a lot of case law in the upper echelons in the Fifth Circuit is in Texas. Well, at least one of the district courts, but like some of them, they have a local order that basically requires a notice and cure period before you can file an ADA Title III lawsuit. So I think that's why you don't see those. It's not going to be a favorable jurisdiction to plaintiffs anyway. As Eric mentioned, most of the cases now are New York and California. New York doesn't have anything directly on point, but it does have enough leeway where they've applied it to intangible spaces. And so, there's just an active plaintiffs bar up there and they file a lot of these lawsuits. And quite honestly, because New York attorneys are generally a lot more expensive, they get settled and they get big settlements because no one wants to pay to litigate those type of cases. Although I have successfully defended a couple in New York. on personal jurisdiction
I was
grounds.
gonna say personal jurisdiction is probably.
Yeah, because I mean, one of my clients was a Florida college who got sued about its website about closed captioning on its videos, which, as a side note, like there was only one video and it was just like a recruitment, hey, look at our great campus, that didn't have closed captioning, and they fixed it. But also, you know, there was no jurisdiction to sue them in New York for a Florida State College website. But I've seen there's a lot of activity in California because the Ninth Circuit has adopted that Nexus standard. But even for purely online businesses, I've seen one case filed and I've seen a lot of letter threats, because there is a case in California state court where it did not directly say this, their comparable California state civil rights law applies to websites, but in that case, it did apply it to a website, or at least the access someone had to a website, but it didn't have to do with the website's accessibility on its own. And so plaintiffs are using that to kind of get that hook to be like, oh, I could sue you under the state law and then I can get damages, which is not available under Title III. So that's why though right now, because of that law that's out there, that's why those two jurisdictions are really active. I mean, I think like this case is going to shut it down in Florida. You know, Florida is where it started. This is where this brainchild really came from. Mm-hmm. There was one attorney in particular who really paved the way. He was the guy on the opposite side in the Gill case. He is currently not practicing because he did get suspended for misconduct in another case.
These things happen. These things happen.
Yeah. But but it's taken off. People took the idea and ran with it, and so it's interesting where it's popped up, being California, New York. Truthfully, the Seventh Circuit, like Chicago, Illinois, I don't know why they don't file more there, because the Seventh Circuit does have law that directly says, the ADA applies to intangible spaces. So like why they haven't picked that jurisdiction and haven't, used that as their home base for these lawsuits, I don't know, but the hotbeds are New York and California, for sure.
So let's say I operate a business. I'm based in Chicago, or I'm based in Los Angeles, and I have a website. What should I be thinking about in terms of avoiding these lawsuits?
Well, the best you can do is to kind of, you can check out your own website. There's a tool on Google, if you're in Chrome, Google, that has a tool under developers tools where you can run an audit on your website and just get a quick feedback as to like where it is on an accessibility store. You go into developer tools and your menu, and when you have the browser open on the website, it's called Lighthouse Reports. And that can give you a kind of quick picture, where you're at. You may already have a high score and you'll think like, oh, good, like we're in pretty good shape. Talk to your web developer if you have one, or the company that, hosts your website or put it together, and ask them, did you take the web content accessibility guidelines into account when you were designing things? Have them run an audit and do what they can. The biggest problem with website accessibility is that it is a very complicated technical area, and it's all and the ADA does actually kind of focus on individual access. It's sort of, even though you'll see class actions, the way it's kind of developed, each person could have a different factual situation and a different reason as to why something might not be accessible to them, and a different solution. So it makes it a little hard to have a one size fits all when it comes to websites, because a person's accessibility can highly depend on what operating system are they using on their computer, what web browser they're using, what version, what type of screen reader software. I mean, a good example is, think about yourself. Like, you might go to a certain website, you're ordering something online, and that website will work okay in like Edge or Firefox, but then it doesn't function correctly in Chrome, or vice versa. I have certain court websites, like will not function correctly in Chrome. I have to go back to Internet Explorer or Edge to get it to function right. Same thing happens for people with screen reader software. So coming up with a one size fits all is very difficult. And so, I mean, unfortunately, it's not great advice. Anyone that tells you though that like they can make your website 100% compliant and you're never going to have any issues, like selling you a bill of goods, because you just can't guarantee that. Websites, technology is always changing. It's not static. And the best thing you can do as a business is just, you know, you got to do the best you can. Be proactive about it, you know, have your web developer do kind of an audit, like like once or twice a year at least, to check and make sure, like, you know, and that, to me, like, I would say look for big functional issues that, you know, would cause someone access. Like if you know, have online ordering, is there something that would prevent the online ordering system from working with the screen reader software? If there's a couple of pictures that are just decorative, you know, images on the website that don't materially, that are just there as like background and they're not tagged correctly, I mean, it's easy fixes, but that's not really what you should be focusing on. Is, you know, when you want to go and talk to your web developer or your IT people, you know, what are we doing? Are we taking this into account? The questions asked is like, you know, what is the function of our website? Like, and making sure that's going to function correctly. And you know, to help stave off lawsuits, honestly, like making that front page get the highest accessibility scores you can is one of the best ways. I mean, I've definitely gotten demand letters from plaintiffs' attorneys for clients, and when I can respond back and be like, hey, thanks, but you know, and I'll quote some of the law, but like, and here's an audit and we have a 95% score, so it seems like we're doing okay, and like I'll never hear back from them again. So it's a good defense, you know.
You just anticipated my next question. What if you do your very best and you get that demand letter anyway? So I'll skip that one.
No, I mean, and you will. And, you know, I mean, thankfully, well, actually, that's not true. You know, Winn-Dixie, even with this victory, I have another case pending in the Southern District of Florida where we got sued again, like only months after the first one in 2016. Some of these plaintiffs and the plaintiffs' attorneys will come, and not the plaintiffs, they'll get a different plaintiff and they'll come back again a couple years later and sue companies again. I mean, there's no way to stop them from filing or making these demands because it's a business and, you know, they keep coming.
Unless you remediate, right?
I mean, well, sometimes even when you remediate.
I guess so.
I wish I could give a better answer. Be like, you do this, and you'll never hear from like any type of plaintiffs in this space ever. Unfortunately, I cannot say that with any confidence.
So, are you anticipating that the Winn-Dixie case will go up to the Supreme Court, or at least the Supreme Court will have the opportunity to consider it?
I mean, I think the plaintiffs, Gill's attorneys have been very vocal about requesting cert from the Supreme Court. So currently they filed a petition for a rehearing en banc to the 11th Circuit. So I'm right now I'm waiting to see if the 11th Circuit is going to ask us to respond to that. And, you know, it's a possibility they may rehear it with the entire court, with all 12 judges. I feel decent that, you know, the majority opinion will stand in the end, but, you know, who knows? And then, you know, I anticipate, like, you know, that they will, assuming like our majority opinion from this case stands in the end, I do anticipate they will take cert up to the Supreme Court. And, you know, who knows? Like, you never know when the Supreme Court is going to take an interest in something. I mean, personally, I do think this is an issue that needs to be sorted out. Because, you know, Winn-Dixie is lucky, at least from like my micro level on this client, they only operate in the 11th Circuit and then like some stores in Louisiana, which is the 5th. You know, for us, this kind of covers us pretty well. But, you know, other businesses that operate across the country, now it's like, well, maybe you can't get sued now in the 11th Circuit, but like you can get sued in California or New York. And there is a definite conflict. And I think someone has to step in and give some finality to this question. And I mean, ultimately, I think the answer is Congress needs to step in and do something about this. And if we're going to regulate websites, say it affirmatively in the statute, and then direct either the DOJ or whatever other regulatory agency they want to cover this, like come up with specific regulations, much like the design standards, so that businesses will know what their obligations are, and so that disabled persons who want to avail themselves of law will know what their rights are. Everyone just needs to know the rules of the game. And right now, it's a free for all.
And we're literally, with websites, we're dealing with literal guidelines right now, right? I mean, I was doing a little bit of research last night. The web content accessibility guidelines, there's a 2.0, there's a 2.1, there's like a single A, a double A. I mean, it's very confusing as to which would apply and which a court may apply to your website, right?
Right, and that was an issue in our lawsuit. And one of the things that I argued on appeal was because there are no regulations, and the plaintiffs generally asked, and I mentioned this before, it's called the Web Content Accessibility Guidelines. And I will say generally, everyone in the industry who works in website accessibility agrees that that's like the best we all have right now as far as to give a guideline or a map to web developers and businesses as to things you would do to make your website accessible. But they are exactly what the name says. They're guidelines. They're not hard and fast rules. They were developed by a private consortium of businesses, individuals, I think some local governments, but it's not a statute. It's not a rule. But in our case, the judge decided for the injunction, okay, yes, that's my order. You comply with the Web Content Accessibility Guidelines. So then he's giving them kind of the force of law by putting them in the injunction. The biggest problem though for that is, their own, Mr. Gill's expert at trial testified that you could never be 100% in compliance with those guidelines. For the reasons I mentioned earlier. Websites change, technology changes, it's not static. I think his testimony was, I almost remember this to the word, the only way you could get yourself to 100% compliance and stay there was you'd have to fix everything on your website, like make it absolutely perfect, and then never change your website ever again. But even if you do that, that does not, like I said, because every individual end user's accessibility is dependent on their own software system. You don't even have a guarantee if you've done all that whoever that individual is going to have the same experience coming to your website with their version of screen reader software on whatever computer they have. So, that is why it's a really difficult issue. And to just say, be compliant with WCAG is not a good solution for businesses because and it's not a good solution for disabled persons either, because it doesn't necessarily guarantee access. And, there is no test or rule that's like, how compliant am I before I'm going to get in trouble? Like, if I comply with 80% of the guidelines, is that okay? Like, it's a difficult subject. And which is why, our position in the lawsuit, my personal position is this is why we need Congress and the regulatory agencies to step in and do their job and, come up with the parameters as to what's going to, cover this area so that, because listen, Winn-Dixie is a customer facing business. Like it always wanted its website to be accessible. Part of the trial was there was a plan in the pipeline even before they got sued to address website accessibility because the leadership of the company at the time knew this was an important issue. They had come from Australia where that was mandated by the government. And so they're like, we want to incorporate that here. That didn't seem to move anyone in the lawsuit, but they continued with their plans because, any business, you don't want to close the door to any potential customer, right?
Right.
But you also don't want to be getting sued because even though you're trying your best is allegedly not good enough, which is why we need rules.
So how do you plan? I get how you could do an audit of your website and do your very best right now and remediate any issues. So absent a rule from Congress or guidance from the Supreme Court, how do you really plan going forward to make sure that whether it's your website or really any Title III issues, we can make it broader. How do you plan to avoid these issues going forward?
It's hard. It's very difficult, particularly when you're facing a plaintiff's bar that sometimes might not be, moved by the reality of a situation. For websites, I actually highly recommend that you have a phone number on the front page of your website that like someone could call and get access and make sure that's going to flag up in a screen reader software, because having an alternative means of access is a way of complying. And there is, I think, I can't remember the exact site, but so kind of a little bit the history of website accessibility. I'm kind of going back in time a little bit here, but under the Obama administration, the DOJ made this announcement that they were going to come up with regulations to regulate websites, except for they never actually followed through. They like proposed the idea, asked for comments, and then they just sort of let it sit there and never actually took the next steps. Then during the Trump administration, they pulled it back and then eliminated it entirely. I don't know, the Biden administration hasn't said anything yet. I don't know what they're going to do. Who knows? They may be seeing our case and saying like, let's wait and see what happens with that first. But I think it was either in the comments or sometime under some of those DOJ notice of rulemaking or advanced proposed notice, there were comments about if you have a telephone line, a staff telephone line that someone can call in and like get help that way, that is a way of providing alternative access. Because it kind of goes back to like, you know, what I said before, not to repeat myself, but, you know, at least to me, the way I see, you know, the ADA is really the goal is getting to the end point. And so if you have a means of the person getting there, you know, that should help you defend against claims. And I may have used that successfully in other lawsuits to say, you know, yes, look, the website we have right here, we have a toll-free staff number. You can call at any time if you're having problems, like, you know, having an accessibility policy that says like, if you're having issues, like call this number, like email us, like, you know, ways to get in touch with us and let us know, like, what's the problem? How can we help you? How can we fix it?
That's good. Got about 5 minutes left. Folks, if you have questions, take advantage. I mean, you've got one of the experts here. My partner, Susan Warner, is joining us, who we've been discussing website accessibility, the Gill versus Winn-Dixie case, Title III generally. Throw your questions up in the chat. I've posted in the chat window ways to connect with Susan on LinkedIn. You can connect with me. You can get a link to our law firm's website and to the YouTube channel for the Employer Handbook. I'll post this video over the weekend on the YouTube channel and have a link to it on Monday. So we've got about 5 minutes left. I don't see any questions yet, but if they come up, we'll answer them. Susan, anything else that we're missing that you think the audience needs to know? This isn't a CLE, so if you wrap it up a few minutes early, you know, we're not depriving anyone of credit. No big deal.
Right. No, I mean, we've covered a lot of ground here. You know, I guess the final, like, if no one has any questions or initial, you know, the final point is unfortunately, there's no way to like stop you from getting one of these letters. But you can implement some best practices to kind of set yourself up to defend them if you get these demands or if you get a lawsuit. Because I mean, at least in my personal experience for my clients, if you've got some best practices already in place, you know, aside from Winn-Dixie of what happened there, you know, having that in place enabled me to like, you know, a lot of times get the plaintiff's counsel to dismiss the lawsuit like for nothing. Literally a walk away, because I was like, we're going to have all these defenses. And, you know, so it's kind of like, you know, Eric Schweitz would tell you, like, in your general employment, you know, issues for the company is document and have best practices and have the right policies and procedures to position yourself so that if an issue arises, like, you're in the best position you can be to defend against those type of claims.
Right, and these are claims that are resolvable, right? I mean, this is not something, if you have that bad day when you get the letter, the demand letter, get a lawyer involved. These are claims that can be resolved pretty quickly, and as compared to a Title I, a workplace traditional ADA claim that most people are used to, these are far less expensive. You're not dealing with the EEOC. you're not dealing, so none of the administrative process. I mean, you get to court faster, which maybe isn't a great thing, but they're easier and faster to resolve. Oh, I have a question for you, Susan.
Yeah.
Are there lines of insurance that you're aware of that extend to Title III of the ADA as opposed to employment practices liability insurance policy that would generally cover Title I?
I am not aware, and that's not to say that might not exist. I think none of my clients have had policies that would cover it. I'm trying to like think off the top of my head, like what the policy would be that would cover this.
I mean, unless you had a potential hire who was trying to complete an application on a website, right?
Yeah.
So you have kind of this hybrid Title I, Title III type claim where you'd have this employment nexus. But other than that, yeah.
Eric just now stopped my heart. I'm like, oh God, that's going to be like the next wave of lawsuits.
I know all these
Title
people. I know the 86 participants who are left in this. None of them would ever do something like that, right?
Don't give the plaintiff's bar any more ideas. Like
No.
They're creative enough on their own.
No. Well, in any event, it's 12:58. We can wrap it a few minutes early. Susan, thank you so much for being so generous with your time today. I really appreciate it. Do you want to let the folks know? I posted a link in the chat window. Do you want to tell the folks anything that's going on or how they can get in touch with you?
Sure. Yeah. I mean, you can reach me. You can email me. You can connect with me on LinkedIn. I'll put my email in the chat here if anyone wants it. We have a website, so all my contact information is on our firm website. Bio, Google Susan Warner Fisher Broyles, you'll find me.
Awesome.
Yeah. If you ever need anything, feel free. If you get that letter, just call me.
Well, congratulations on the big win at the 11th Circuit, folks. Thanks so much for coming out to attend today. I think we're going to take next Friday off. I think I have on my calendar, I have to pick up my kids for early dismissal. So we might have to take next Friday off from the Zoom handbook office hours. But if any of the attendees today have any ideas or topics that they want to see addressed on these office hours, let us know. I mean, Susan, I don't want to be a pig, but Susan's an employment lawyer too. So I may have her back to address something or ask her to come back to address something, but let me know. Otherwise, check it out. If you're seeing this on the YouTube channel, like, what does everyone say now? Like and subscribe and comment below and all that good stuff. It helps the algorithm and people see the video and all that crap. Great. Do that, please. Otherwise, if you're watching this live, you can sign off now. Have a great weekend. Stay safe. And I'll see you soon. Bye.
Thanks, everyone. Bye.